Be ready. 5 seconds. Start. In addition to above, the Learned Counsel for the petitioners has submitted that in the present case there is no disclosure in the impugned order that the petitioners had played fraud or had submitted forged documents or that they were not otherwise eligible for the post. Therefore, as there was no fault on the part of the petitioners and the selection process was concluded after due advertisement of the posts, there was no valid reason for the university or for the state respondent to treat the appointment of the petitioners as illegal or void and cancel the same without even providing opportunity of hearing to the petitioners. It has been submitted on behalf of the petitioners that since the appointments were made in the engineering college when at that time it was not a university, the appointment procedure was governed by model bylaws governing the engineering college. It has been submitted that under the bylaws, appointments were to be made upon recommendation of the selection committee and the selection committee for the post of Group C and Group D was to be constituted as per the direction of the principal director of the engineering college. It has been submitted that the appointments were made upon recommendation made by the selection committee which was duly constituted by the then principal of the engineering college. Therefore, the appointments were not void or illegal which could be cancelled without opportunity of hearing. It has also been submitted that had opportunity of hearing been given to the petitioners before cancellation of their appointment, they could have satisfied the authorities that the appointments were legal and valid and that they call for no interference. In the alternative, it was also submitted on behalf of the petitioners that once their appointment was given effect to and their service had been confirmed consequent to the reconstitution of the engineering college as a university, the service of the petitioners could have been terminated only after following the procedure prescribed by first statutes of the university. The Learned Counsel for the respondents submitted that Rules 2002 would be applicable to the engineering college because it was a government funded engineering college completely under its control, though established through a society, and therefore its establishment, management and running was well within the affairs of the state, and as such rules framed under the proviso to Article 309 of the Constitution of India, in absence of any clause excluding its applicability on the engineering college, would be applicable, and as such the appointments made without following the prescribed procedure were illegal and void. The Learned Counsel for the respondent university, however, could not dispute that the impugned order passed by the registrar of the university, as also the resolution concerned of the board of management, including the impugned letters of the state government, did not specifically cite infraction of Rules 2002 in making of appointments in respect of the petitioners, though the enquiry report in respect of B.B. Singh does refer to the same. I have given thoughtful consideration to the rival submissions. From the record and the rival submissions, what is undisputed is that the petitioners were appointed in the year 2009 and thereafter they were confirmed and paid salary and they became employees of the university consequent to the reconstitution of the engineering college and that their appointments have been cancelled without opportunity of hearing to them. In Jaising versus State of Uttar Pradesh and others, 2013-16 SCC 441, before the apex court, an issue arose as to whether appointment of a principal in a college could be cancelled without giving him opportunity of hearing on the ground that the appointment was void because it was made by way placement order passed by the director even though the vacancy in the college concerned was not advertised.